And here they come. Okay, good morning, everybody. Thank you for joining PMCA's Women in the Mechanical Industries COVID 101 Roundtable. We're going to be talking about legal and HR perspectives on how to handle COVID-related employment issues today. I'm Lori Rawlings. I'm the Executive Director of PMCA. I'm your host and the moderator for today. I'm going to start by giving you a few background housekeeping items. We're recording today's session, so if you don't want to be recorded, feel free to turn off your video. We'll probably be posting this recording on PMCA's website when the session is over today, provided we have enough bandwidth to do that. And now I'd like to introduce our speakers. Allison Kruger. Can you raise your hand, Allison? She's an employment lawyer at Dunn Carney here in Portland, and she's been practicing law since 1996. A significant part of her practice focuses on helping employers navigate the ever-changing landscape of employment laws in Oregon and Washington. And ever-changing is an understatement in today's world. Nicole Farrup, raise your hand. She's the owner and principal consultant for Good Company HR. And she provides customized human resource guidance, support, and training for companies of all sizes and industries. And finally, Mark Tilkins. Mark, can you raise your hand? Mark is an experienced labor lawyer and the office managing principal of the Madison, Wisconsin office of Jackson Lewis PC. He's often called upon to provide representation and strategic counsel in high-stakes labor and employment matters and other crisis situations. So welcome, everyone. I appreciate you being here. Okay, just to cover a couple other housekeeping items. We have had a number of questions submitted in advance from the audience. I want to thank you guys for taking the time to think about your questions and submit them in advance to facilitate an efficient and productive conversation today. We're going to go through overall introduction of the topics and then those pre-submitted questions until about 11:45. And then at that point, I'll turn it over for questions from the audience. To keep things functioning smoothly, I would ask that you use the chat feature to submit those questions. And you can either submit them to everyone in the group, and I will take them and present them to our presenters if we have time. If you don't feel comfortable asking your question to everyone in the group, you can submit it to me privately so that your name isn't attached to it. I won't be reading people's names when I ask the questions anyway, but if you want that additional level of privacy, feel free to do that. I may ask those questions as they come up, or I may save them till the end, depending on how the conversation is flowing. And then I want to provide a couple of disclaimers before we begin. The guidance and the advice that we are receiving from the federal government and other sources changes regularly. So because this is a developing situation. So what you hear today may change tomorrow or an hour from now as we learn more about the virus and its spread. So please keep that in mind and please be patient. And the other disclaimer is that although we have lawyers on this call, what we're providing is general guidance and general rules. Nothing that's said today should be considered legal advice or legally binding. It's always the best practice to consult your own attorney if you're unsure or if you have questions, because every situation is very fact specific. Okay, with that, I'm going to go ahead and introduce our first topic. So what we want to talk about first up here today is the various leave laws and how they interact with coronavirus. And specifically, we're going to talk about some of the new emergency coronavirus related laws, but also some of the existing laws on the books and how they interact with each other and what they mean during this coronavirus pandemic. So I'm going to turn it over to Allison at this point for a general overview.
Thank you, Lori. Good morning, everybody. I want to just start out by covering some of the basics about the leave laws that are in play now with COVID-19 and your workplaces. The big one, as Lori mentioned, is the new federal law, the Families First Coronavirus Response Act, which Congress passed back in March. It became effective on April 1st, and it has it changed the landscape around the Family and Medical Leave Act pretty significantly, and is extremely different from the FMLA that we all know and love or don't love, and we're all very comfortable with and used to when this new law was passed. So just really briefly, overview of this law. So the FFCRA has two provisions. The first provision is the Emergency Paid Sick Leave Act portion. And this portion covers an employee and allows them to take up to 2 weeks of paid leave when the employee either has COVID-19, has symptoms and is being evaluated for COVID-19, or is under a quarantine order from a doctor or a public health authority, or if the employee is caring for someone that fits into one of those categories. So this is 2 weeks, up to 2 weeks of paid leave, and it's whatever the employee's normal schedule would be. So if it's a part-time employee, it's going to be 2 weeks of part-time leave. If it's a full-time employee, then it's going to be 80 hours. This provision also permits an employee to take 2 weeks of paid leave to care for a child due to a school or place of care closure because of COVID-19. And that piece of the Emergency Paid Sick Leave Act dovetails in with the other piece of the law, the other provision in the law, which is the Extended Paid Family and Medical Leave Act. And this is the part of the law that amended the Family and Medical Leave Act and provides up to 12 weeks of leave to care for a child due to a school or place of care closure. Under this provision, 10 of the weeks are paid. The other 2, the employee can either use the emergency paid sick leave, time off, so these 2 pieces kind of work together there, or they are allowed to use other forms of paid leave under the employer's policy, or paid sick leave under state law. Or it can be also taken unpaid those first 2 weeks. So those are the 2, those are sort of very brief summary of those 2 provisions. This law is kind of unusual, the FFCRA, in that it only applies to employers that have less than 500 employees. So completely different standard than the FMLA. And of course, then it's really only applying to, I'd say not the super large employers, but large, medium, and small employers. Other types of leave that employers need to be thinking about in the time of COVID-19 is the expansion to the Oregon Family Leave Act. If you have Oregon employees, this is an expansion that permits employees to use up to the full allotment of OFLA for school closures or place of care closures. And I guess maybe the most common situation where that could apply would be for a very large employer where the FFCRA does not apply. But again, it's OFLA leave, it's unpaid, and it's probably not going to come into play, significantly often for the folks on this call. There's also paid family and medical leave under Washington law. And that's, of course, if someone is ill and needs time off or fits into one of the other categories for that paid leave. This is the new paid leave program that some of you may be aware of in Washington. And then we also have, of course, this traditional Family and Medical Leave Act leave, which would really probably only apply if someone was either off work due to having COVID-19 and needed more than the amount of emergency paid sick leave that they were entitled to under the FFCRA. They needed additional time off to recover, or they're caring for someone in that situation. So those are kind of the big points there under the leave laws, and things that you need to sort of keep in mind when looking at a scenario with an employee who needs leave. I'm going to turn it over to Mark and ask if he has any comments in terms of how all of this may be impacted by labor law.
Yes, thank you, Allison. Good morning, everyone. There's 2 points that I think are worthy of mentioning in connection with the labor law landscape here. The first is whenever there's a compulsory new employment requirement or benefit, even if it's state, federal, doesn't matter, if the government mandates a new provision in connection with medical leave, FMLA, paid sick leave, these are all conditions of employment, and therefore there still is a duty to bargain with the union if you have represented employees. So for an employer that has a represented workforce, there's an obligation to bargain with the union over the effects of the government's decision, not over the decision to implement the benefits, because those are compulsory. The government's set forth the eligibility criteria, but the effect on the employees is something that must be bargained. Now, the second point, which is the good news part of this, is unlike what we all believe and have lived through, the normal collective bargaining process when a contract expires and an employer is seeking a new labor agreement, which is a very long, drawn-out process, the process of bargaining over the effects of a compulsory new condition of employment or benefit like this is a very efficient and fast one, and there's even an exigency provision under the National Labor Relations Act, which allows an employer to quickly move through the process of satisfying the duty to bargain over the effects. And it really can come down to just a couple days or even less than a week, an exchange of correspondence with the union to satisfy that duty. It's a process, not an outcome. Thank you, Allison.
Thank you. I'm going to add some. Oh, I'm sorry. Hi, Lauren.
No, I was going to say, Nicole, do you have anything to add?
Yes, I apologize. So I'll add a few. Just to put the HR lens on it. And thank you for mentioning what you did, Mark, because I'm going to lead off of that. Is make sure that the first thing you need to do is review your policies and review your practices. So sometimes we have policies and we're practicing things differently than our policies, but you want to make sure that you know what all of your time off and paid sick time policies are. And then you need to look at all of the other available programs and the compulsory programs that are now being put into place. And how do all of those things work together? What can run concurrently? What can't run concurrently? And then in regards to things like the paid family medical leave, the separate program in Washington, that is that one that both employers and employees pay into, which is in effect their state short-term disability program, which Oregon is going to be starting to implement in a few years. You know, that, how does it intersect with that? So when are people eligible to use that? And, you know, do we stack all of these things together? What runs concurrently, what doesn't? And every case is really, every business in every case is unique. And so there isn't a one size fits all. It's just a matter of making sure you know what all the programs are that are, you know, that you're required to comply with, and making sure you already know what your policies and your processes and protocols are. And in some cases, with some clients that I've seen, this has been a really great opportunity to take a look at what your policies and practices are, and are you actually following your policies and practices? Do you even know what they are? Are they being, you know, sometimes we see that, you know, some policies become fairly liberal. So, you know, if you're not tracking time for your exempt folks, and now you have situations where you need to be tracking, you know, what kind of a reconciliation do you need to do there, or a redress? So keep thinking about those kinds of things. Also make sure that you have the postings, because with the FFCRA, there is Allison was referring to, there is a posting that was required to go out as well as be posted in all of your workplaces. So make sure that you have that as well. So yeah, so with that, that's that. The only other thing I did want to mention actually is with the FFCRA, with the extended paid family medical leave, it does apply to some employers where traditional FMLA does not. So just make sure that you have that. If you already think that you don't have to comply with FMLA or OFLA or Washington family leave, family and medical leave, you may have to comply with the FFCRA extended paid family leave as well. So keep that in mind as well.
Okay, thank you guys.
Thank you.
So with that, I'm going to take it to our first question, which is actually a very common question. And that is, if employers are being asked to send workers home for 14 days if they are exposed to someone who has tested positive for the virus, do employers have to pay for that time? So I'm going to hand it to Allison first.
Thanks, Lori. So this is a question that I am getting very, very often, and it is causing a lot of confusion for employers. You know, under the FFCRA, just being sent home by the employer due to exposure with a positive case does not qualify an individual for paid leave. Now, if the person is put under quarantine by their doctor, then they are qualified for paid leave. So what I've been recommending a lot to clients is that if they are sending employees home, that they have the employees contact their physician. And if the physician also orders them to stay home, then the employee would qualify for the paid leave. But technically under the FFCRA, paid leave is not required unless there's a doctor's order or a public health authority that quarantines the individual. Mark, did you have any labor law thoughts on that?
Yeah, it could be, depending on the particular labor agreement for those employers who have represented employees. It could be that sending them home does trigger a contractual promise to provide paid time. And so that's completely divorced from any legal requirement that exists apart from a contract, but just on a baseline contractual contract law standpoint, even absent any government compulsory obligation under the paid sick leave provision of the FFCRA, it could be that your labor agreement has language that compels that time to be paid if the employer sends the person home. So that's an individualized analysis. It depends, and it's dependent upon the labor agreement. And it's consistent with Nicole's comment about check your own practices and procedures. If you do have that as pre-existing contractual promise, you would have to then provide that as paid time. Thank you.
Just to jump in with regard to 290's labor agreement, we have, PMCA has bargained with 290 to allow temporary furloughs during the coronavirus pandemic emergency. And as long as the employer is following CDC and Oregon Health Authority guidelines in terms of who to send home and for what period of time, 290 has been very good about treating that as a temporary furlough under which the employee can apply for unemployment, and they haven't been insisting on wages being paid during that time. But if your policy is stricter than what the CDC and OHA guidance have recommended, you may run into an issue there. And we have an employer who's in that situation right now, and we're trying to still sort through it. So in general, if your policy is in compliance with CDC and Oregon Health Authority, 290 has been treating that as a furlough situation. Nicole, did you have anything else to add on this question?
Sure, just a reminder to keep checking back with the CDC, because in the case with Local 290, with the, as long as people are following the CDC guidelines or the OHA guidelines, then they're allowing the temporary furlough. Well, the CDC and OHA guidelines have changed a few times. So keep on top of things and keep looking at those websites and your resources on a daily basis. Now, the CDC and OHA guidelines haven't changed for a while, but that doesn't mean the more we learn about the virus, that doesn't mean that it won't. So, because there are new studies coming out that may suggest that we should do a second degree isolation with exposures, but that's not the guideline just yet. So yeah, just keep after that. So actually, Allison, I wanted to kind of ask you a question about this that comes up for all the time that I think might be kind of helpful, that it's helpful for the folks is, can they require the use of paid sick time? So if you do have employees, not necessarily represented employees, but at-will employees within your organization who you have a sick time policy for, or maybe even bargained for, can you require the use of sick time and PTO if it's optional otherwise, if you have to send someone home for quarantine?
You know, I think it would depend on what the employer's policy is there. It's not, if you're talking about sick leave that's outside of the legal requirements for paid sick leave under state or federal law. So I think it would really depend on what the employer's policy says. And so it would be an individualized assessment. I mean, I think it's really best if it's not mandated in your policy to make it optional for employees so they have the choice of whether they're going to use that paid time off if it's strictly a employer imposed quarantine.
Yeah, absolutely. I agree with that. And thank you. And the other thing that I might suggest too is that you take a look at, do you have extra resources? Is there anything that you can do or you can provide in addition? Because you do want to keep people engaged, and you do want to keep people there and working for you. And so sometimes if you have reserves or there's some way that you can expand or do a temporary extra paid sick leave or anything like that, that's always a good thing to look at as well.
Great. Okay, let's turn now to return to work issues. And the first issue is masks and face coverings. Allison, could you take that one for us?
Sure. So, I mean, this is the hot topic of the month, is masks and face coverings. And I'm just going to go kind of quickly through the current requirements in Oregon and Washington. Most of you, I'm sure, are very familiar with this. In Oregon, adults and children 12 and older are required to wear face coverings in any indoor public setting, such as grocery stores, pharmacies, public transit, personal service providers, restaurants, bars, retail stores, and any outdoor public places where they cannot maintain at least 6 feet of distance from others. It's also recommended for children ages 2 to 12. There are some exceptions, limited exceptions. Masks and face coverings are not required when interacting, where an employee is not interacting with the public. When an employee is not eating or drinking, eating and drinking that covers everybody. And when individuals are performing strenuous physical exercise and can maintain at least 6 feet of distance from others. So these restrictions kind of overlap both the workplace and everywhere else. There are no religious exemptions. That's a question that's come up. We will talk a little bit about accommodations for individuals who have medical conditions or disabilities that may impact their ability to wear a mask or face covering. Right now in Oregon, enforcement is through OSHA, I believe, and I don't think law enforcement is getting involved in these issues, which has caused some amount of consternation for Oregon businesses. In Washington, there are currently 3 orders in place concerning face masks and coverings. Individuals must wear them indoors in any public setting and outdoors where social distancing cannot be maintained, again, 6 feet of distance. And employers, what's a little different in Washington is that employers are required to provide face coverings for employees. And again, businesses in Washington are required to enforce these state mandates. I really recommend, if you haven't done it already, that you take a look both at the Oregon Health Authority and the Washington State coronavirus information websites that have a lot of details about the face mask and face covering requirements. There's so much detail. I mean, we could spend more than an hour just talking about this specific issue. So it's important to take a look at those. There are also notices to be posted, and the information about those can be found on the state's websites. On the ADA, I'm just going to focus specifically on employer-employee issues here, not customer issues, because I don't know that this group would have that much of an interest in the customer side of it. Under the ADA, an employer is required to provide a reasonable accommodation to any policy that the employer has, even mandated policies such as the face mask, face covering requirements from the state. And so in this case, this is the requirement that employees wear masks or face coverings while at work. Of course, the facts and circumstances of each scenario are going to control how the employer responds. However, although the employer has to provide a reasonable accommodation, the employer does not simply have to allow people to work without a mask, so or face covering. Again, it's very, fact specific, but some common accommodations include things like, continuing or allowing remote work, having an employee work in a space where they're not interacting with others, the use of a face shield, which presents fewer issues for people who have disabilities. And then, if there is no accommodation, then potentially allowing unpaid leave. There's a lot of complexity around the issue of accommodations for disabilities. And so if you have this scenario come up, I'd suggest that you, reach out to whomever you rely on for advice, legal and HR advice, to get help working through those issues. Let's see, Mark, how about masks and face coverings in labor law?
Thank you, Allison. Yeah, we have the same issue that we'll have to address here under labor law as we did in connection with the paid sick leave and the FMLA issues, which is that if there's a change in the working conditions for employees who are represented by a union, that change is a mandatory subject of bargaining. And so with a mandatory subject of bargaining that's being impacted by a government or an employer required change in connection with, it could be bump caps, it could be gloves, it could be, think of all the things that OSHA has imposed at the federal and state level over the years by way of changing working conditions in the interest of safety. Masks and the wearing of masks is another one. And so in this case, we'll be looking at the labor agreement. The 290 labor agreement under the management rights provision does not have a waiver of the duty to bargain, but it could be that an individual employer has its own practice of imposing very minor changes in safety procedures over the years, which would allow the employer to unilaterally make that change now. But if that isn't the case and you have to bargain the effects of this with the union, it's as simple as, from a practical standpoint, it's as simple as an email or a letter that says, "Dear Union, we have been notified that we're obligated effective July, whatever the date is, to require our employees to wear masks under the order issued by," fill in the blank for the government agency, and we intend to comply with that. Please let us know if you wish to discuss this or negotiate over it. It's really as simple as sending something like that. If they wish to discuss it, we can listen to their proposals, but again, it's a process, it's not an outcome, and so it's actually a very simple process to complete. It is, however, unlawful under federal labor law to not go through the process. Thanks, Allison.
And PMCA, as your bargaining representative, is working very closely with 290 on those issues as they develop. And 290 has been very, very reasonable to work with on the changing fluid situation regarding masks. Okay, Nicole, did you have anything you wanted to add?
Yeah, I actually had a question. So what if the mask requirement, because so like OSHA has some really great resources for employers. They have these guides that they these best practices guides for construction sites. But what if their suggestions for best practices for safety in light of COVID are more or go further than what the executive orders are? Is that something that could also be collectively bargained, or is that something that employers could do?
Mark?
Yeah. Yeah, thank you, Nicole. If there is something that has not been compelled by the government, in other words, if there's a recommendation that the government offers, or even a private safety outfit or some sort of best practice that exists or comes into existence, those things, if they're not compelled by a governing body, may be something that the employer can make the union bargain over in the midterm of an agreement. And I say may because generally the labor agreement and all of the things that it restricts and allows is the entirety of the things that can be imposed. And you can't, neither side can make the other side bargain over new things that they just have a good idea about, whether it's based on a best practice or a recommendation from a government agency. There's an exception to that, however. When there's an exigency, an emergency situation, and COVID-19 presented some of this, even for employers before the enactment of the FFCRA, you can compel, one side can compel the other side to bargain over something that is an emergency situation, a unique situation, and the National Labor Relations Board has allowed that in rare circumstances, and COVID-19 is a rare and unusual circumstance. So in connection with that, if there is something that's unique to the industry, Nicole, to your question, an employer likely, in these circumstances, does have an ability to make the union collectively bargain over a change in a working condition that is not compelled by the government. But it's going to be an individualized analysis, and it's not going to be as automatic as something that's been compelled. Thank you.
Okay. Yeah, thank you so much for that. So the only other things that I would add is two things. Anytime making an accommodation, which this will come up in later questions as well. So I wanted to mention it now. You know, a really great resource for employers is the JAN network, the Job Accommodation Network. I highly recommend that you visit the website, that you take a look through all of their resources. They have a really great interactive process guide. But the best part of JAN is that you can call them and ask them, here's my situation, what do I do? And they are going to help you. They will help you. They'll answer questions. It's not legally binding. You still should consult your HR or legal, legal resources as well when in doubt. But the JAN network is a really great asset. So so that's something that I encourage everybody to familiarize themselves with and kind of make part of your regular life. Particularly with accommodations. And then the other thing from an HR standpoint is just do a little bit of brainstorming and think about if we're going to be, do we provide masks or do we allow our employees to bring masks, or the people who are working for us to bring their own masks? And if so, what's the standard and how do we communicate that to them? And, are there other options or alternatives that we can provide, like face shields or things like that? And so those are some things that you want to think about too, is if you're going to have, if we are requiring masks and you're going to have masks or face coverings, what are those going to be? What are the alternatives and who's going to provide them?
Great. Okay, so that leads into a couple of questions. First one is, a client or a business partner told me they have a constitutional right not to wear a mask. Is that true, Allison?
No. As a general rule, the Constitution does not apply to private businesses. It only applies to things that the government is doing. So, this is coming up a lot. And in the workplace, if someone says, well, I have a constitutional right not to wear a mask, you can tell them the Constitution doesn't apply here. Put your mask on.
Yeah,
excellent.
Absolutely.
Mark or Nicole, did you have anything to add on that?
I do. Or I'm sorry, Mark, did you have something to add?
No,
okay,
actually, there's no labor issues on this one, so Nicole, it's all yours.
Okay.
Yeah.
Nicole?
So what I was going to add is prepare your, if you're dealing with, and I think Allison, as you stated earlier, you may not have too many people from the outside or clients or partners coming in, but you might have a client or you might have a partner who comes to the work site and is like, I'm not wearing a mask or whatever. Offer some options. So offer for them to stay outside of the workplace, and you can do a Zoom, you can do a FaceTime or a Zoom call where you take them around to wherever they need to go. Offer them a face shield. Anyway, just think about some of the alternatives or things like that. And if you do have to deal with the public in any way, think about the PR issue behind, requiring masks or not require, or what are the, there's going to be a little bit of a PR issue. So you want to be sure and anticipate, like, hey, we think we might have problems in this area. What would our response to be? How can we train those people or prepare those people who are going to have to deal with people who don't want to wear a mask or don't want to comply with the executive orders? How are we going to train those people in being able to address that effectively and smartly?
Okay, great. And we're starting to run short on time, and we have a number of questions to get through. So let's move right into the next one. And that is, an employee told me they can't wear a mask due to a medical condition, and that I don't have the right to ask them what the medical condition is. Is that true? Allison?
No. So employers may ask for proof of a medical condition that requires an accommodation under the ADA. It's different if you're just dealing with a business, asking a customer, why can't they wear a mask? That's a different scenario. But in the workplace, an employer is entitled to ask for proof of the medical condition that restricts the use of a mask or face covering.
Mark, any thoughts on that?
No, nothing to add from a labor perspective.
Great. Nicole?
No, nope. I have nothing to add from the HR perspective that we haven't discussed already. Yeah.
Thank you. Okay, well then let's move into physical distancing at work. Allison, can you take this one?
Sure. So as you all know, both, well, every state, but Oregon and Washington in particular have issued executive orders that have a lot of rules for employers to be following in terms of what happens in the workplace. There's also lots and lots of guidance out there from OSHA, WISHA, and so forth. And I just recommend that you take a look at all of that and make sure you're familiar with it and you know where the resources are and how to get to them. I was going to try to summarize where the two states are at right now, but realized this morning there was no way to do that in less than about 25 minutes. But I just recommend that you, become familiar with those resources and be checking back frequently.
Great. Okay. Mark, did you have labor law thoughts on this one?
Yeah, there can be obligations to bargain with the union in connection with changes in the workplace that relate to how employees move and or where they work. So, for example, if a physical distancing rule changes significantly in a meaningful way where the employee is performing work or how they do it, there can be an obligation to bargain over that. Absent some sort of meaningful change, though, there won't be.
Great. Nicole?
Yeah, I think that it's, from the physical distancing, there's some really great resources out there. The CDC has an excellent preparing your workplace or returning to work guide, and OSHA has a really great workplace tools planner for construction sites as well as for workplaces. And so instead of my going, like Allison said, we could go through like, oh, do this, do that, stagger this, stagger that. I suggest that you look at those and really do what we call a Gemba walk through your workplace, which is management by walking around. So you walk around and look at your workplace and think about how do we operate and how does work happen, and then you create your own plan from there about what kind of physical distancing is needed.
Great. Thank you. Okay, so then another topic is remote work. And one of the questions that comes up frequently is some of our workers are successfully working remotely. When we are able to return to the office, will we be required to continue to allow them to work remotely? Allison, what do you think?
No, you do not have to allow people to continue working remotely just because it's been working fine during this time. In-person work can be required by the employer, and it does not have to be it does not have to be justified by the employer, as long as the employer is in compliance with whatever executive orders are in place. Of course, if you have employees that need accommodations for medical conditions, you may have to allow those individuals to continue working remotely. But that's kind of a separate issue to the, do we need to justify bringing people back to work? Also, there's the question has come up, what if we have an employee who has a vulnerable person in their household? Do we have to accommodate that employee by allowing them to continue remote work? And the answer is, under the law, under the ADA, an employer does not have to accommodate in that scenario. However, they of course can do so. And I've had many of my clients who've made the decision to permit that. And I know some larger employers are permitting those accommodations.
Great.
Mark, thoughts?
It can be that if you allow a practice to occur for a significant period of time, that it becomes a binding past practice under labor law. So it is possible for the change from a workplace performance of work to a remote that goes without objection from a union, and then it's possible for the remote work to then become a condition that is part of the unwritten terms, implied terms of the labor agreement, such that there would be a duty to bargain to bring them back. That doesn't mean that you can't do it. It just means that you may have to bargain it back, which is why for employers who've changed the working conditions of represented employees, it's always important at the beginning of it to write the MOU or the correspondence to the union to indicate that the employer retains the right to bring them back to the workplace. That way that you don't have a fight at the end of that period. Thank you.
Yeah, I'm sorry.
Oh, I was just going to say, keep in touch with me about any of these issues, because I'm in contact with the union on a daily basis. And, we've had a lot of these issues come up already. So if you have a question about anything, definitely feel free to pick up the phone and give me a call at any time. And if it hasn't been discussed with 290, it will be. Okay, sorry, Nicole, I didn't mean to cut you off.
Oh my gosh, no worries. Yes, absolutely. I agree. Yep, and to kind of take off from what Mark said is it's a very good idea to notify employees, if you have not already, who are working remotely, that this is temporary, that this is not intended to be, that this is a temporary situation. We're not intending this to be, and when conditions change, then we are going to ask you to come back. And then when conditions change and when you do want to bring people back, you want to be careful about, you want to be thoughtful, and you want to communicate with them ahead of time and tell them what to prepare, and you want to make sure that your workplaces are prepared and that you address any fears or any issues that might come up because of that. So communication is key.
Great. Okay, that leads into your COVID response plan. What do you do in case you have a COVID case in your workplace? So let's go to Allison.
So it's really, really important to be familiar with the resources that you need to refer to before you have a case so you can respond quickly. And I think the number one place to go is the CDC. It has a lot of very good information about how employers work through a positive case in their workplace. The scenarios can be different. And so we're going to talk about a few potential scenarios, but it's really a good idea to just be aware of the resources on that website. So when it happens, you have a place to go. You can look up the latest information, because what we're talking about today may change, and then, act accordingly. And of course, the employer's response is going to be determined to some extent by the circumstances. An employee who develops symptoms during the workday is going to require a different response than an employee who was last in the building 5 days ago and is now tested positive for COVID-19. So the place to go first is the CDC website. Oregon Health Authority is very helpful. And of course, your local public health, county health authority also. Nicole, or I guess, Mark, do you have any labor law thoughts there?
Nothing to add to that. I don't think there's anything to add at this time. Thanks.
Okay.
Nicole.
Yeah, so having a response plan is really important, and I agree with Allison. So currently it's, there's there's some days to keep in mind, which are the 10, 3, and 14. 2, 10, 3, and 14 are those days that you want to keep in mind. So if people, you want to, because it's very complicated, and it's really complicated, and I don't know that it's easy to say this is what you do and this is what you do for your response for if somebody is positive. Instead, it's good to have a decision tool and a policy that's like, if you are sick, if you're in contact with someone sick, if an employee is sick, this is what you do, and creating that. And so I really encourage everybody to consult the CDC and to do that ahead of time. Consult the CDC, talk to your HR resources or your labor law resources, and create that policy and that kind of decision tool to make sure that kind of what you're going to be doing, and that you inform people around you, that you inform your employees and you inform your staff that this is what the policy and the process is going to be. Some important things too to keep in mind in those policies and processes goes back to what we talked about earlier, which is the questions that get answered are, am I going to be paid? If I have to go home, am I going to be paid? Are you going to pay for my COVID-19? Are you going to pay for my test if I have to have a test? Are you going to pay for my doctor's visits if I have to have my doctor's visits? So those are questions that you want to look at your collective bargaining agreements. You want to look at are they an at-will employee? What are your rights and what are your obligations to pay for those things? If people are employees and at-will employees, then you will have to pay for those costs, any of the out-of-pocket costs they incur. Under the collective bargaining agreement, that would be something that Mark you could speak to, whether they would have to pay for that or not. So those are the things. So you want to be able to answer all of those questions. You want to have those questions answered ahead of time.
Great.
Yeah.
Okay, so a couple quick questions that maybe I'll ask Allison to take. What do you do if you have an employee who did test positive for COVID-19 versus what do you do if you have an employee who has a sick household member who is tested positive for COVID-19? You're muted, Allison.
Sorry. So yeah, so there are sort of different responses for those scenarios. You know, I always tell clients they should contact the county health authority if they have a positive case in their workplace, or if they have an employee who has a positive case in their home and is questioning whether they should be coming to work or not. In the case of an employee who's tested positive for COVID-19, in addition to contacting the county health authority, that individual should be quarantining for 14 days from the day that the test was taken to determine that they had a positive result, or per whatever medical direction they receive. Anyone who's had close contact with the person confirmed to have COVID-19 in the prior 3 days and has no symptoms should quarantine for 14 days after the last day of contact with the person that has COVID-19. Of course, close contact there's a lot of different ways of looking at what's close contact. If the person then develops symptoms, then they should also quarantine for 10 days after the symptoms appeared, and at least 3 days after, and for at least 3 days after their respiratory symptoms subside and their fever is gone without the use of fever reducing medication, or if they've had 2 negative tests taken within 24 hours apart. I tell clients a lot of these questions, they are medical questions, public health questions, and not legal questions. And so it's really important to look at what the guidance is coming from the CDC. And again, it hasn't changed lately in this area, but it could. And also it's just hard to keep track of all the details of what you're supposed to do. But being familiar with where to go into the CDC's website to get these answers is probably the most important thing. What if an employee has a sick household member and they themselves have not tested positive and have no symptoms? Generally, employees who've been exposed and have had close contact with someone who's infected should remain at home and quarantine for 14 days. Potentially exposed employees who have symptoms of COVID-19 should also self-isolate, follow the CDC recommended steps. And, but even people who don't have symptoms, if they've been in close contact, they should quarantine. Did I answer that all, Lori?
I think so. I mean, Mark, do you have anything to add?
No, nothing to add from my perspective. Thank you.
Great. So a couple other questions. If an employee is sick and sent home pending a test, does the employer send the other potentially exposed employees home at the same time, or do you wait for the test result?
I would say yes. I mean, if an employee is exhibiting symptoms of COVID-19 and they've had close contact with coworkers, those people should be sent home, because it could be a few days before test results come back. In the meantime, you know, if those people have been infected, as we've all been hearing, asymptomatic transmission is a real thing. And so in that scenario, if the ill employee is showing symptoms and we're just waiting on a test result, I would send home the coworkers that have had close contact with that person.
What do you think, Mark, from a labor perspective?
Yeah, that could involve a duty to bargain, and so in that situation, there ought to be things that, at least from a 290 perspective, that these employers are aligning with you ahead of time, Lori, with regard to how agreeable or not agreeable you think the union will be on that. But sending people home is a change in their working arrangement and conditions. It does impact the labor relationship, and it may be permissible or it might not be, but that analysis is one that should be looked at.
And I've been in close contact with 290 on this issue, and as long as the CDC guidelines and the Oregon Health Authority guidelines are being followed, they've been agreeable to employees being sent home in a situation where there's been a possible exposure awaiting a test result.
That's been true for other unions across the country too. They have an interest in not having their other members infected as well. So for most of the COVID issues, we are seeing across the country that labor and management have quite a few things in common on a common ground.
Great. Another question is, when can an employer request a medical release or at least 2 negative tests 24 hours apart? And what if that's not possible? Allison, thoughts?
Yeah, and quickly on that, I mean, under the ADA, an employer is allowed to request a medical release or the 2 negative tests 24 hours apart. Um, if that's not possible, then the recommendation is to follow the CDC guidance on when it's safe for the person to end isolation and return to work. And that's typically, as I said, at least 72 hours with no fever and no medications to reduce fever and the other symptoms have subsided. So at the beginning of all this, it was very difficult for people to get tested. And it was, there was some concern about whether it would be possible to even get a doctor's note. I think getting a doctor's note now, at least from what I've been seeing, is not that difficult. Telemedicine visits can work for that. Getting tested is becoming a little more complicated here in Oregon. And so, you know, maybe a scenario where the person is not able to turn in a negative test results in order to return to work. In that case, the 72 hours with no fever, no fever reducing medications and other symptoms subsiding is the general rule.
Great. So we're at 5 minutes to 12. At this point, I'm going to ask, do any of our panelists have a hard stop in 5 minutes, or is it okay with you guys if we keep pushing past 12 to get our question answered?
I'm available until 1:15.
Okay.
Yeah, I'm available.
Okay, then what I'm going to suggest is we get through all of our pre-submitted questions, and you know, if our guests have to jump off, this is being recorded, and I'll make it available as soon as the recording has been processed. So if you can't stay past 12, you can still have access to the remaining questions and answers. Okay, so that takes us into employee accommodation issues. So here's a question. What if I have an employee tell me they have a comorbidity or an underlying health condition or fear of working even if they are not exposed to a positive case? Do I need to let them stay home? Allison.
So employees who are at high risk for contracting or for becoming very ill if they contract COVID-19, they may be entitled to an accommodation of working remotely or some other form of accommodation. Individuals who, again, you've got to look at this from a reasonable accommodation perspective, just like any other medical issue that impacts the person's ability to perform the essential functions of their job. Again, you know, interactive process is going to be important here, having a dialogue and figuring out what's appropriate for this employee. May allow them to need to continue working remotely if that's possible. Leave is also a possible accommodation. Fear is not something, just generalized fear is not something that has to be accommodated, but I think we're going to cover that in another question.
Okay.
Let's see, Mark, any thoughts on this from the labor lawyer perspective?
Yeah, this one's actually fairly easy from a labor perspective in that this works just like it would before COVID-19 from an ADA perspective, in that if an employer has an obligation under the ADA or any state equivalent to provide an accommodation, any inconsistent labor law requirement, practice, or provision will have to bend so that the disability accommodation can be provided. And it could be that it makes sense to have a dialogue with the union because prospective communication on these topics avoids fights and disagreements, but the accommodation must be provided, notwithstanding something that says in the labor agreement that says it different.
Great. Nicole, anything to add?
Yeah, right. Go through the interactive process like Allison was talking about. Anytime somebody has, this is just an important management recommendation, just when you're managing people in general. Just when people have fears or they have questions or any issues that come up, don't be afraid to have the conversation and don't dismiss it out of hand. And so even if it is just fear or, you know, or something, it's worth going through, hey, so what's going on? And what is it that what are you looking for? And if it's not something you can see, do you request a medical verification or not? And you know, and go through that process with employees and do what you can to kind of set their fears at ease. Two things to think about: if you have people who you are going to allow to take leave and they cannot work remotely or they're not working remotely successfully, You do have to keep in touch with them, and you have to have some kind of a limit on how long you're going to hold their job, how long you might be required to hold their job. And in that case, I actually would ask Allison or Mark if you can weigh in, like how long do people have to hold jobs if it is for an accommodation situation where they cannot work remotely? Like what would be reasonable? Or is there even an answer to that?
Yeah, it's very fact specific. What's reasonable for a very large employer that has a lot of people who can fill in and do the job that the person is unable to perform because of a disability. A long period of leave might be reasonable. Whereas if it's a small employer and they don't have anybody to fill in and it's going to present a hardship to the business to keep functioning, it may be that just a very small amount of leave or even no additional leave beyond what's required by law would be considered reasonable. So those are all the ADA accommodation issues are extremely fact dependent and have to be looked at, individually to make a decision there.
That leads into our next question that I'm going to hand to Allison. I mean, you
I
have
actually have one last thing I'm so sorry. One last thing that I wanted to add to that when you're making these accommodations, like for people, in any case when you're making an accommodation, but especially if you have people who are going to be on leave because for whatever reason, you need to be consistent in how you treat people and in how you follow that interactive process. So if you are going to allow somebody to be on leave who claims to have a comorbidity and you don't require medical verification, and you're going to allow them to be on leave indefinitely, and then someone else comes to you, you can't use a different process per person. You need to be consistent with your process. So anyway, I just thought I would add that.
Yeah, that's a great point. I appreciate that. Speaking specifically about fear, let's say you have an employee who's told you they're too afraid to return to work, but they don't have work that can be performed remotely. Allison, how would you respond in that situation?
Yeah, generally plain old fear doesn't have to be accommodated. And unfortunately, this is a situation that a lot of employees and employers are finding themselves in right now. However, if the employee actually has a mental health issue and that's why they're afraid to come back to work, their mental health is really preventing them from returning to work, that maybe does need to be accommodated, just like you would accommodate any other medical issue. So you really have to look at those situations individually and find out, as Nicole was saying, ask questions like, what's going on? How are you feeling? Why are you afraid to come back to work? If all you get out of the employee is, I'm just scared, the virus is everywhere, I just don't want to be in the workplace, and they don't offer up that they have a mental health issue, I wouldn't necessarily ask that question, do you have a mental health issue? But if they're not offering that and they're just saying, I'm just scared, you just have to do your best to make them feel at ease as far as explaining what you're doing in order to make the workplace safe. And also you have to be able to make a decision about what will you do with somebody who's just got plain old fear and doesn't want to come back to work. Is it important to you to keep them as your employee for when things get back to normal? How are you going to handle those scenarios? So again, they're all very fact specific.
Mark, did you have anything to add on that one?
No, nothing to add to that one, Lori.
He's passing. Excellent. Okay, well then let's move into our next topic, which would be travel for business or personal reasons. We've got a specific question on that one. And that is, if my employee is planning to go out on a vacation to a state with a lot of cases, such as Florida or Texas right now, or Arizona, can I ask them not to go or ask them to quarantine when they return before returning to the job site? Allison, what are your thoughts on that?
So yes, you can ask the employee not to go. You can require the employee to quarantine when they return. You don't have to pay them for the quarantine period, at least under, any non-labor law consideration, unless they are an exempt employee and they've worked a portion of the work week, in which case you do have to pay them like you would, in any other scenario. It's difficult to ask people not to do things in their personal lives, but as long as they're aware of the consequences of going to Texas or Florida, I think it's perfectly acceptable to require them to quarantine when they return. And there's certainly nothing in the law that prohibits an employer from doing that.
Mark, what are your thoughts?
Yeah, same labor law considerations as we discussed earlier in connection with an employer required, not a government required or a medical required quarantine. If the employee chooses to travel to a location that is a high-risk location, it could be that the labor contract imposes an obligation to pay for that, but that's totally independent of any paid sick leave that's required by the government.
Okay, Nicole,
Yeah.
do you have thoughts on that?
Yeah, the only thing that I would add is communicate that ahead of, if you can, I would come up with that policy and communicate that ahead of time. It's tough to do things in the wake. Because we're under direct threat, it's arguable that you could do that in the wake. Allison, I would ask you to weigh in on that. But it is always a good idea to say, this is going to be our policy. So if anybody, between now and whenever things change, for the foreseeable future, if you are going to travel to a place that has, that we consider a significant risk, then we're going to ask you to quarantine, or we may ask you to quarantine. I would suggest that you state those things ahead of time and communicate them ahead of time to people so they can make informed decisions.
Great. Okay. So then I would say the next set of questions are kind of best practice questions that I think are mostly Nicole questions. So we can start going through them, and then if Allison or Mark has anything to add, feel free to jump in. But one question is job site sanitation. What's necessary, what's recommended? What do you think about that, Nicole?
Well, yeah, absolutely. And I think we have talked about this offline ahead of time. And I do agree with that this is a big conversation, and it's a longer conversation than one we might be able to really have answered here. And specifically, the question was related to women's hygiene, I think women and women's hygiene and what I can tell you is that, all job sites and actually, Mark, you probably know about this as better than I do. All job sites are supposed to have private, accessible, clean bathrooms with accessible water and soap or hand sanitizer or sanitizing kits when not available. And under the current circumstances, the OSHA is recommending that they have to be wiped down regularly and cleaned twice a week. And that there may be, and that if you're in agriculture, there's actually further rules if you're in agriculture, or if you're housing labor, there's going to be some rules that you have to pay attention to. So because it deserves a longer conversation than that, what I would suggest is that, follow the rules that you're supposed to be following and look at what the OSHA workplace controls are, and talk to your employees if they have concerns, how can you address those concerns? So that would be my response to that. Do Mark, Allison, do either of you have anything to add to that?
No,
I don't have anything on that topic.
Yeah.
Okay. So then the next question is, what constitutes an outbreak? I mean, how many positive cases do you need to make it one? And at what point does it get reported to the local news and then everyone knows about it? What do you have for us on that one, Nicole?
Yes, currently the Oregon Health Authority, and I apologize, I'm not sure what the Washington Health Authority has determined, but currently the Oregon Health Authority considers an outbreak to be 5 or more cases that can be traced back to a business at any time. So not just in like this week or this month, but for the entire time of COVID, they consider that to be an outbreak according to their standard right now. And so it becomes a PR issue at that point. If you do have 5 or more cases, then it's important to think about what would your response be? What would you have a response to the public? Would you say we're committed to, reviewing our practices and seeing what we can do to better protect our employees, staff, public, customers, whatever it is that you need to do. So think about it ahead of time. What would you say and how would you approach it? And then the other thing you might consider is look at what other employers who have had these huge outbreaks attributed to them, what have they done? How have they responded? And how's it been effective or not been effective? Those would be my recommendations. The other thing, you're going to have an internal PR concern, because now this is going to cause a tremendous amount of fear among your employees when you have that, when this happens. And so be prepared to respond to that too, and do respond to that. So talk to your employees and tell them, hey, we get it. This is really scary. Can you provide testing for them? Can you take a break? You know, they do say that if you are able to leave a job site or a building for 7 days, the CDC, for over 7 days, they feel like that's a safe period of time for them to be able to come back into a work site. Can you do that? Can you shut down at all? What cleaning can you do? What other resources can you provide? Are there any things that you're not doing that you should be doing for employees? And then going back to number one, you need to communicate with people and check in with them and make sure they're okay, that you're talking about their fears. And, you know, sometimes when employees have fears, there may not be anything more that you can do, but it is important that you at least listen and hear them out.
Right. Excellent. So here's one. The next two questions I think are kind of weighing on everyone's mind. The first one is, there appears to be no end in sight for COVID, and more employees are becoming testier, sensitive, or disgruntled. What can we do for our employees, and what suggestions do you have for us to manage differently through a crisis?
Yeah, this is a really great question, and it is it's coming up more and more. It's, you know, we're in it's a difficult time, right? But it's really going to depend on your industry and what your situation that you're in as an employer. So again, keep in touch with your employees and check in regularly. Acknowledge that people are having challenges and that this is a stressful time. Not having a conversation is far worse than being afraid that you're going to say the wrong thing, or for not having that conversation. You know, you want to be thoughtful. So be thoughtful, seek clarification and understanding, allow employees the opportunity to give you feedback, and apologize if you say the wrong thing or if you do the wrong thing. Just be open and don't be defensive, and, you know, and practice empathy in your listening. So determine who your resources are ahead of time. So who do you have for HR? Who's your employment attorney? Are there other business owners that you feel like can be in your inner circle, the people that you trust? And, you know, Brene Brown has a great term for this. It's called your square squad. So who are those people that you can really trust, and that you can talk to and say, hey, I have this problem and I need some help. I need some help solving that. So rely on each other. Then you also want to look at what your resources are that you have. So do you have an employee assistance program available to you, or through your union? Does the union have an employee assistance program? You know, very likely, I believe the local 290 benefits have one. Is that true?
It's getting up and running at this point.
Getting up, perfect. And in absence of an EAP program, you know, consult local, you can consult your medical providers as well. So make sure that you know what those resources are that you can offer your employees. You're also not therapists, so do be careful about giving therapeutic advice, but you can listen. You can do what you can that's in your purview as an employer. You can offer these resources through your benefits programs, and get help and support when you need that. But and then the last thing that we're doing in the HR community quite a bit, really encourage people to use PTO, even though it seems kind of weird. You know, if we're all working from home, PTO, so I just stay home, you know, I have a stay at home thing. I'm just turning off my Zoom. But do encourage people to take their PTO and use their PTO. It's not only good for your liability reasons, but so you don't have a ton of people all wanting to take PTO at the same time when we're able to go places. But, you know, it's good for people's mental health to take a few days off, even if it is just to disconnect from Zoom.
Yeah, and I mean, that leads into a question we got about one of the contractors themselves is tired and overwhelmed. And so I think that's good advice for you guys who are on the call. You should make sure you take some PTO as well, not just encourage your employees, because we're all in the same storm together. So it's very important, if you want to be an effective manager, that you're also taking care of yourself. And finally, we have a question that is weighing on a lot of people's minds and is maybe not necessarily 100% on topic, but I think is a good question, which is, as a working parent, what can we do to prepare for this fall? Nicole, do you have any thoughts on that one?
I do. It's a tough one. It's really tough. But from a business standpoint, because again, you know, we care about our people, but we can't necessarily take care of their personal problems for them. But what we can do as an employer is be strategic about our own, you know, how are we going to operate if this happens? So I suggest what are you going to be your strategic plans depending on whether kids are able to go back to school or not able to go back to school, or like in Salem, it's going to be a combination of part-time distance learning and part-time in-person. I think they're doing something where some kids can come back to school for a few hours, you know, they're staggering it. So there's going to be a lot of different things going on, and we don't really know, and we're not really going to know until September 1st what exactly is going to happen. So what I suggest is that you make a 1, 3, 6, and 9 month strategic plan, because we do know that on the horizon, you know, there's been some really good news about vaccines. There's a couple of organizations here in the United States and abroad that have made incredible progress on vaccines. And so we're hoping in six to 9 months, we'll have a vaccine that will be readily available to all of us. But until then, make a plan. So what are going to be your 1, 3, 6, and 9 month strategic plans to address how you need to adjust your business? What's the impact going to be if schools don't open? What so far have you done to accommodate parents? Can you continue doing that? What did you learn from that? What employees and what jobs are going to be really impacted? And is there any work that you can adjust or pivot? Then you also want to make sure who's going to be eligible for benefits under FFCRA, because, you know, as Allison was sharing with us earlier, you know, there is the emergency, you know, the extended paid family medical leave, which is specifically designed for parents whose children don't have daycare or childcare. Can your business afford to extend leave benefits if employees are not eligible otherwise? Can they be part-time? So are there any other supportive resources that you can provide? Tutoring, I don't know. There's no end to how creative you can be. It's really up to you. So instead of getting weighed down by the problem of it, pivot and try to reframe it to, okay, we just have to respond to the times. We have to respond to the times. We have to continue business. We have to continue going forward. And so how can we actually solve it? What is the problem? Where do we need to be? What's the solution, and how can we get there? So use kind of your frustration as an impetus to solve a unique problem. So that's my, and that's going to be really good for morale for your staff as well. If your staff sees that you really care and you're really trying to find a solution, then you can. The other thing you can do is you can develop, you can engage your staff in helping you find these solutions too. A lot of times your staff, because they're the ones doing the work, they're going to have better ideas than you are anyway. So that's another thing that I strongly suggest, is engage them in the process.
That's really, really great advice. So we've come to the end of all the pre-prepared questions, and I think we've covered all the questions that came in through the chat. So at this point, I'm going to ask the panelists if they have anything else that they want to say as we wrap up here. So start with Allison. You're muted, Allison.
Yep. Yeah, I guess the only thing I would add just on what Nicole was just discussing about what to do in the fall, the FFCRA is effective through December 31st. So I guess, you know, we'll be paying attention to whether that law gets extended depending on what happens with schools getting back into session or not getting back into session. But right now the benefits under the FFCRA and as of December 31st. And otherwise, I don't have anything else to add, but thanks for asking me to participate today.
Thank you so much. Mark, is there anything else you wanted to add?
Yeah, only one point, which is during these times, employees more than ever are coming to work with more anxiety and despair than ever before, and they're really in need of their employer, their leaders, managers, HR professionals to be a rock of stability. And if we can provide that for them and constantly engage with them with an attitude, if it's important to you, it's important to me. Now, that doesn't mean we are in the business of giving them everything they want. Backing up the money truck during financial difficult times is not necessarily going to provide for business survivability. However, it doesn't matter what the issue is. If they have something on their mind, that should be important to me, their leader. And this is, I think, very much the COVID-19 situation, and all of 2020 as well, really should be viewed as an opportunity by us as leaders in the workplace to show employees that in a sea of tremendous change, that we are the one aspect of their life that is a place of stability. And it'll build morale. It will help keep any union difficulties down if there's a represented workforce. If it's a non-represented workforce, it quite frankly is a method of avoiding vulnerability from organizing on the part of a union, because they're getting everything they need from their employer by way of leadership and communication. Nothing beyond that, Lori. Thank you.
Thank you, Mark. And Nicole, any final thoughts?
Yes, that's excellent advice, Mark. Thank you. You said it very, very well. And the only thing that I have to add is it is absolutely okay if you don't have all the answers. That doesn't make you weak. That doesn't make you a bad leader. It doesn't make you a bad boss. It's okay not to have the answers. It's okay to tell people, I don't know what to do, but I'm here for you. So yeah, that would be the only other thing that I have to add.
Great. And in that spirit,
you.
Thank you, Nicole. And in that spirit, PMCA is here for you as well. So if you have questions, you have thoughts, things that you're not sure about, please feel free to contact me at any time. And if I don't have the answer, I have a great support network here, obviously made up of these professionals and my colleagues all around the country who are working on these same issues. So use us as a resource. And with that, I want to thank everybody for being here today, and special thanks again to Allison Kruger, Mark Tilkins, and Nicole Farrup for their expertise today. Thanks, everybody. Have a great day.
Thanks, Lori.
Thank you.
You as well.
Bye-bye.
Take care. Bye-bye.